Thank you, Mr. Speaker. Can I thank the Secretary of State for advance sight of his statement? This is an incredibly serious moment. It's the first time Section 35 has been invoked. Donald Dewar has already been mentioned, the father of devolution, of course, designed Section 35 to protect devolution. It was passed by all parties in this House and hasn't been objected to since. It was intended not as a blocking mechanism, but an enabling mechanism, so that the Scottish Parliament could pass legislation and devolve competencies without changing reserved functions. There was concern at the time by colleagues of the Secretary of State that this could be used as a veto. So a memorandum of understanding was agreed. It said, and I quote, "Although the UK Government is prepared to use these powers if necessary, it sees them as very much a matter of last resort. The UK Government and the administration concerned will therefore aim to resolve any difficulties through discussion so as to avoid any action or omission by the devolved administration having an adverse impact on non-devolved matters." So can I ask the Secretary of State, is this a last resort? Has the Secretary of State had extensive discussions with the Scottish Government before taking this action?
No.
How many times has the Secretary of State met with the Scottish Government before the bill was passed, during its debate in Holyrood and since its passage? It appears to me that this has only become a last resort in terms of the legal timing because both governments can't and won't work with each other.
Yeah.
The Secretary of State says the Section 35 is being used, among other reasons, in relation to the Equality Act. Both the Scotland Act and the Equality Act are landmark pieces of labour legislation, establishing devolution and enshrining rights to be free of discrimination in law. Nobody has to question this party's commitment to equality. We passed the initial GRA, we brought in the Disability Discrimination Act, and we got the world-leading Equality Act into law. But clearly, there's a need for laws passed by Holyrood and those by Westminster to interact. And in this case, the trans community need that cross-border interaction to work. Part of the reason that after 25 years of devolution, Section 35 has never been exercised is largely because of the way devolution was set up and intended to operate. Governments with their own agendas, but with a common purpose, working together to serve the Scottish people. Now Scotland is saddled with an administration in Edinburgh that's hell-bent on breaking devolution and a Conservative administration here in London that's intent on ignoring it. Indeed, the Secretary of State seems to spend more time with government lawyers to stop things happening rather than make them work, and the Scottish Government is spending hundreds of thousands of pounds on lawyers challenging laws they know are unchallengeable in order to manufacture political grievance. And in this case, it's the public who are let down. Trans people who suffer intense discrimination will now not see this legislation take effect anytime soon, if at all, and women's rights groups who will likely not see their concerns addressed or their fears alleviated because this simple truth is that this has turned into a constitutional bun fight. Yeah. I would also suggest that the SNP would be rightly screaming, and they are doing today and would do so in the past, if a piece of legislation passed in this place had implications for default competencies. They would challenge that, and they would rightly challenge that, as is their right. And if we are to accept the argument from the Scottish Government that there is no effect on the Equality Act, then the courts will surely strike out this Section 35 action, as we believe the Scottish Government will take it to court. Mr. Speaker, can I also ask the Secretary of State, Scottish Labour got the primacy of the Equality Act on the face of the Gender Recognition Bill. Will the statutory instrument that he detailed in his statement give the details of where he thinks it is incompatible?
Yes.
The Secretary of State said last night there was a version of this Act which the UK Government could support. So what does that look like? But he says in his statement there are complications with two different gender regimes. Is he saying the Scottish Parliament shouldn't have the competence? As the bill was debated in Holyrood, was it not obvious to him and to his colleagues that it could contravene reserved law? What did he do about it then? During the passage of the bill, Scottish Labour made clear that if the bill was to work, clear guidance was required. The SNP Scottish Government said it was for the Equality and Human Rights Commission to provide such guidance, not them as the government. Why doesn't the Secretary of State instruct the EHRC to provide that guidance, look at the cross-border issues he mentions, and provide recommendations as to the interaction of the Equality Act? Both governments should commit to accepting those conclusions. Or is the Secretary of State saying that the ball is only in the Scottish Government's court to bring back amended legislation, and he now backs out of the process? Mr. Speaker, we support the principle of updating the GRA, which when the Labour Government introduced in 2004 was world-leading, but 2 decades on now requires modernisation to humanise and to remove the indignities in this dreadful process. We've ended up in a legal and constitutional impasse. My final question to the Secretary of State is, what is he going to do to resolve it?
Yeah. Well, Mr. Speaker, to answer his questions, hopefully in the right order, it is not a last resort. To understand the Scotland Act, the Section 33 is where the UK legislation is directly changed, and Section 35 is when it's adversely affected. And we have 28 days to make a decision in either case before the legislation goes for royal assent. And in this case, the legal test that has been given to us and proved by our officials is one of Section 35, which is adverse effect on on two parts of UK/GB legislation. So that's where we're at. We have 28 days to make that decision, and we have to make a decision in that time frame. And in this case, this very senior legal opinion advises us that a Section 35 is appropriate. And we will see that in my statement of reasons, which we have laid with the order. On his second point, officials have been meeting with officials in the Scottish Government since the bill was introduced. And the Minister for Gender and Equalities wrote, after the second stage, wrote to the Bill Minister expressing her concerns and asking for a meeting, and that meeting took place. And again, her concerns were expressed at that meeting. Regarding the EHRC, the EHRC have said that they're willing to work with and support the Scottish Government if they can. However, they make it very clear that their ongoing concerns are still on the record, and that's where that rests. And I think that addresses all the points that he raised. Well, but if any are not addressed, I'm sure others in the chamber will ask those questions.